that the Supreme Court has overturned affirmative action in over 50 years of legal precedent, what does that mean? And what does it look like for you and your family in the African American community? Stay tuned right after this. Hey y'all, what's up? The United States Supreme Court just dropped a bomb on this country and in the legal community with this decision today to overturn affirmative action. My name is Attorney Chloe Corbett, also known as the Duchess of Justice, and with me I have
Attorney Augustus Corbett, aka the Minister of Justice.
Welcome to our channel. We are the Defiant Lawyers. Each and every week, we provide you with legal analysis of trending politics, policies, personalities, and pop culture. What's up?
Go ahead, Chloe.
Oh, can you all hear me?
Yes, go ahead.
Okay. I said, what's up, Dad? We have huge news today to discuss, don't you think?
Oh, yes. This is big time news. And, we got a lot to discuss.
Yes, we do. So for those of you all who may have been at work and who've not been on social media or heard the news, today the Supreme Court decided to overturn affirmative action. And this has potential huge consequences on college admissions in the future, as well as other areas in American life. Dad, this decision is not surprising due to the makeup of this court, due to the fact that there's a 6-3 conservative supermajority. So we were not surprised whatsoever. In fact, we were anticipating it. The Supreme Court came out with a wrinkle a couple of weeks ago with this decision about the Alabama redistricting that state tried to do. But this decision was not surprising. What are your initial thoughts?
That's right. Yeah, we almost knew this would happen. The Supreme Court has been looking at affirmative action to abolish it now for many years, at least far back as, well, first of all, back to the Bakke case, and then the Grutter case out of Michigan, and then the University of Texas case out of Austin. They've been trying to overturn this for years and years. So now that they have this supermajority, like you said, they were able to get it done.
They were. And this case was heard by the Supreme Court back in October of last year. The decision was just entered today, and it's actually two cases, one against Harvard College and one against the University of North Carolina Tar Heels, which I'm a personal fan of. Go Tar Heels all day. But the Supreme Court popped it a little bit with this decision, and basically it ruled that affirmative action is unconstitutional under the Equal Protection Clause of the 14th Amendment. And the court issued a 200-plus page opinion by Chief Justice John Roberts, as well as several concurring opinions and several dissenting opinions by the 3 liberal justices as well. And we have been poring over these 200 pages for the past few hours since this opinion came down. So I am ready to get into it, Dad. I think we can put the first slide on.
Okay. So the first thing we see are just some general observations from this case. I think, as I look at it, Chloe, I think the result today occurred because of 3 major reasons. Actually, there are 4. One is the conservatives' long game. I mean, these folks think 40, 50, 60, 70, 80 years out, and they keep grinding and grinding and grinding. Conversely, blacks are basically reactionary folks. We just react to stuff. We don't have a long game. Part of that is because we are not unified. You know, the white community is not a monolith either, as we are not, but they agree on one thing. And that one thing they agree on is white supremacy. And I believe that cuts across the board, whether liberal, Democrat, libertarian, Southerner, Northerner, Westerner, Southwesterner, rich, poor, whites agree that this country should be ruled and controlled by whites. Um, they can agree on that. We don't have some sort of guiding principle like that. We're not unified. And that disunification showed up today in this court opinion because you had the two black justices who were basically going for it, going after each other. Clarence Thomas and Ketanji Jackson. We'll talk about that later. But the third thing is voter suppression. The GOP is very adept at suppressing black votes. That played a part in this, in the Trump election. And then black voter dispassion. This is where blacks sometimes just don't vote, just stay home, just enough for the opposition to win the races. So, which brings me to the next slide. And I know you got things to say about this one, but it brings me to the next slide, which simply says elections have consequences.
That has been shown today, Dad, as well as the other opinions that the Supreme Court has rained down. And why? Why do we say that elections have consequences? Because the justices that are sitting on the highest court in the land are appointed and nominated by presidents. And former President Donald Trump was able to put three, and correct me if I'm wrong, I believe it's three justices on the bench. Correct?
I think so. Yeah, Gorsuch, Kavanaugh,
Yes.
and
Yes.
Barrett.
Yes. So, with his election in 2016, in just 4 short years, President Trump put three extremely conservative, um, I would dare say, kind of against the black equality and black justice agenda, and have made decisions that have negatively affected the black community. And this is another decision that this court has made, with a super majority that was created by Trump, um, that has negatively affected us. So elections have consequences. I always have friends and people I know tell me, well, I'm not going to vote because my vote means nothing, or the same type of people are in power, or our politicians do not care about us. But if you pay attention to anything, this decision is going to reverberate for generations and generations to come. When it comes to college admissions, who has access to higher education, and the caliber of higher education that Black Americans have fought and died for so many years. This is a slap in the face to those people and to the activists who came before us as well, with the Supreme Court ruling that affirmative action is unconstitutional. So, it, I mean, there's no truer words that have been said, in my opinion, in terms of politics and America, that elections truly do have consequences.
Yes. And the court used the 14th Amendment to invalidate affirmative action. How ironic and offensive when the 14th Amendment, when Congress added it to the Constitution to give citizenship rights, equal protection rights under the law, and due process rights to African Americans specifically. And yet they used that very same law to invalidate a program that was designed to benefit African Americans. And it's that type of question, Chloe, that critical race theory gets at. And I want to say that up front because the past couple of years, conservatives co-opted critical race theory and redefined it. And the definition they gave it means absolutely it it does not reflect what the founders of critical race theory developed the word to mean. In short, they were trying to simply say, how is it that we have the 13th, 14th, 15th Amendments, the Civil Rights Act of 1866, of 1964, the Voting Rights Act, all these laws to protect Black rights, yet Blacks still keep experiencing disparate outcomes. Why is this? That's what critical race theory was designed to answer and to address, not all the garbage that conservatives attach to it. But, they are just better at, again, the long game, the short game, creating narratives, co-opting words, redefining them. They're just better at that than we are. Um, so yeah, so let's put the holding of the case so that folks know exactly what the court said about affirmative action and why it is no longer the law of the land.
Yes. And keep in mind, guys, we are two lawyers. We're not pundits. We're not political commentators. So you're going to be hearing a bunch of opinions about this case and about this, what this decision. But we are going to be giving analysis and analyzing what it means legally, and then just in terms of society as a whole. So keep that in mind too. So we're going to go into a lot of detail. That's the benefit of listening to the Defiant Lawyers. So as you see here on the screen, the holding. This is what Chief Justice John Roberts wrote for this opinion. He said, "We have permitted race-based admissions only within the confines of narrow restrictions. University programs must comply with strict scrutiny. They may never use race as a stereotype or negative, and at some point they must end. Respondents' admission systems, however well intentioned and implemented in good faith, fail each of these criteria. They must therefore be invalidated under the Equal Protection Clause of the 14th Amendment." So that is the holding in Students for Fair Admissions Incorporated, which were the plaintiffs, versus the president of Harvard College. That is what Chief Justice John Roberts wrote in his opinion about why they declared that affirmative action is unconstitutional. So that the first question likely is going to be, and we'll get into this later too, what is the Equal Protection Clause of the 14th Amendment? Why is that so important? And we'll discuss it more because it implicates the decision that was made decades ago in Brown versus Board of Education, where the Supreme Court said that separate but equal schools were unconstitutional under the Equal Protection Clause of the 14th Amendment. So this decision implicates all of that language. And, a lot of us who are in this sphere, we believe that this decision could reverberate not just in college admissions, but in other areas as well that were implemented by the federal government, by the Constitution, by the amendments, etc.
Yes, and
Would you agree with me?
absolutely. And also, I would say that, um, the 14th Amendment goes back to the Dred Scott decision, which where Chief Justice Roger Taney, said that we were basically second-class citizens and we had no rights that whites had to observe. That was the Dred Scott decision. That was the awful language that was in that decision, which precipitated the Civil War. So the 14th Amendment, when the Civil War ended, the abolitionists, both white and black, moved quickly to add the 14th Amendment to the U.S. Constitution so that it would basically overturn or repeal the language in the Dred Scott decision. And again, it contains the Equal Protection Clause that we're to be treated as African Americans equal under the law. and that we have certain due process rights. Things cannot be done. The government cannot do, states cannot do certain things to us without due process, and then citizenship. All that's embedded in the 14th Amendment, and none of that, none of what I just said, suggest that it should ever be used to invalidate a program to benefit blacks. So how did conservatives twist the 14th Amendment to use it to invalidate something like affirmative action that was designed to benefit blacks? How does that happen? How does the 14th Amendment, which guarantees equal protection under the law, how is that used to invalidate affirmative action?
Wow. I mean, it's that's what makes it so infuriating, for those of us who are woke and who are knowledgeable about, how important the 14th Amendment was for African Americans to integrate us into society after slavery ended, and now circle back 200 plus years later for it to be ended on the basis of, the effort to diversify education and to allow African Americans to have equal access to higher education. That somehow violates the equal protection clause. I mean, honestly, that it makes no sense to me. The analysis that the Supreme Court came out with, uh, it was very, in my opinion, very circular analysis. And we'll get into it deeper and more specifically that, but it just does not make any sense.
Yeah, I would say that the U.S. Supreme Court is broken.
Yeah.
Um, I would say that it's broken because, if you have ideologues on the court, and that's what I believe those six conservatives are. They are ideologues. They have an ideological bent that they will advance through these cases. Now, they say that other judges, they are the primary ones who say that judges should not be activist judges, that they shouldn't legislate from the bench. But that's precisely what they be doing. I mean, it's precisely what they be doing to accomplish their ideological beliefs. And as I read this opinion, Chloe, today, I'm like, these folks, Chief Justice John Roberts is basically coming up with the rationale to achieve something that he has worked against all his professional career. Chief Justice John Roberts started in the Reagan administration, and he worked in the Justice Department to fight both the Voter Rights Act and affirmative action. So this has been his lifetime professional goal, as well as Sam Alito, as well as Amy Coney Barrett, Kavanaugh, um, Thomas. This has been their goal. So it's not about what precedents hold. It's not about equality, what's equal, the equal protection clauses is not about that. It's about achieving their ideological, again, goals. So this opinion, for example, let's start delving into it. As Chloe said, some of this is going to be maybe us sort of geeking out legally, but it's necessary to really fully understand what this case means, because it will reverberate, not, as Chloe said, not just in college admissions, but the language in this case will be used to invalidate any number of programs designed to help African American people. So with UNC's admissions program, Chief Justice says, John Roberts says, UNC's admissions program operates similarly. The university frames the challenge it faces as the admission and enrollment of underrepresented minorities, a metric that turns solely on whether a group's percentage enrollment within the undergraduate student body is lower than their percentage within the general population in North Carolina. The university has not yet fully achieved its diversity-related educational goals. It explains, in part, due to its failure to obtain closer to proportional representation. Now, all that simply means is UNC said essentially, we're trying to have a student body population that mirrors the population of our state. So if African Americans represent 10 or 15% of North Carolina's population, then we believe equality would say that 10 to 15% of our student body should be African Americans. If whites represent 50% of North Carolina's general population, then whites should be 50% of the population, of the student body population. So that was the goal that UNC has. And I think that is a very worthwhile goal. I mean, that sounds legitimate to me. I'm from North Carolina. I know that there are a lot of I know that a lot of North Carolinians are African American. And so whatever the population of African American, what percentage of the population there is in North Carolina, then the schools should reflect that, especially public schools, right? Especially schools like UNC, the first public school in the country and the flagship public university in North Carolina. But, as we'll see here, um, he said the problem with these approaches is well established. Outright racial balancing is patently unconstitutional. That is so, we have repeatedly explained, because at the heart of the Constitution's guarantee of equal protection lies the simple command that the government must treat citizens as individuals, not as simply components of a racial, religious, sexual, or national class. Okay, we got to stop there and talk about that a second, Chloe. I'll come back to you in just a moment. Couple things going on here. So the biggest type of racism that African Americans face is systemic racism or institutional racism, or you could say group racism. We are discriminated in this country as a group, not as individuals. And and as individuals. But what's most problematic is how systems and institutions discriminate against us as an insular group, is the word that the court has used in previous cases. And now most people don't understand that, and they tend to pay close attention to individualized racism rather than the systemic racism that we face. When I talk about systemic institutional racism, I'm talking about the fact that if you look at a system like healthcare, or if you look at wealth, or if you look at education, if you look at the criminal justice system, you will see that African Americans fare worse as a group than all other groups in the country. But he says in this opinion that the court does not recognize systemic racism, that according to their interpretation, the Equal Protection Clause was not designed to address group discrimination or systemic discrimination. The 14th Amendment, according to them, only addresses individual racism, in individual equality. Now, I don't know if I explained that well, Chloe. Help me out.
Yeah, so I mean, basically, I think quoting Justice Thurgood Marshall as Justice Jackson did in her dissent will highlight what you just said, Dad, about the systemic racism that Black Americans still face, even though individuals within the Black community may have PhDs, may be lawyers like us, may own businesses. But as a group, systemically, how do we fare against our white counterparts? That is the point that we're trying to make. And what the Supreme Court is saying, well, no, we're not going to look at how Black Americans do as a whole, or systemically, or the way that systems treat the Black community as a whole. Instead, the Supreme Court is saying that the government must treat citizens as individuals, not as simply components of a racial, religious, sexual, or national class. But that contrasts what Justice Marshall said, in the opinion in the Bakke decision back in the 1970s, which got rid of racial quota. So basically, universities couldn't say, "Well, we want to have 100 African American students, so we're going to make sure we meet that quota." But what the Supreme Court said is that race can be used as a factor, as one of several factors, with universities admitting students. And that has been the law of the land since 1978 until it was reversed today. But in that opinion, Justice Marshall said 350 years ago, the Negro was dragged to this country in chains to be sold into slavery, uprooted from his homeland and thrust into bondage for forced labor. The slave was deprived of all legal rights. It was unlawful to teach him to read. He could be sold away from his family and friends at the whim of his master, and killing or maiming him was not a crime. The system of slavery brutalized and dehumanized both master and slave. I think that this quote from this opinion that gets to the heart of it. We were brought here, as chattel slaves, and then we were then subjected to 100+ years of Jim Crow and separate and unequal treatment. So you really can't just focus on the individual African Americans as a whole if you're not going to address it. If you want to, have this country and systems address individual Black Americans on our own merits, and address the wealth gap, address the educational gap, address the healthcare gap. Do all of that, Chief Justice Roberts. If that's the way that you interpret that the Equal Protection Clause of the 14th Amendment applies to us. But I strongly disagree with it.
All right, great. Thank you for quoting Justice Marshall, who is all up in this because Justice Jackson, Ketanji Brown Jackson, she is representing the Marshall wing of the court. There hasn't, Justice Sotomayor and Justice Kagan, you could say, represent that wing of the court. But Ketanji Brown Jackson seems to me has become the leader in representing the Marshall wing of the court. And I want to make sure, Chloe, that even African Americans themselves understand what we're saying when we distinguish group racism versus individual racism. Because a lot of Blacks would say, what is the big deal? I'm doing fine. I have a good job. I'm a homeowner. I have a nice car. I'm doing okay. What's the big deal? I don't see what the big deal is here. I don't see why there's always, coming from certain Blacks, this thing about race. I'm okay. I'm doing well. Well, it's not just about you, sister or brother. It's not just about you. It's about us as a group. And there is a lot of racism that you face as an individual that you don't even realize. It's so pervasive, you don't even see it. You don't feel it because it is so pervasive. For example, that good job you're talking about, I have a good friend, Barry Jenkins. He tells all the time about on his job, he's an engineer, he's a retired engineer. And on his job, he was doing this important work, building these very sophisticated airplanes. Him and a group of other engineers, he was like the only Black in the group doing the same work that his white colleagues were doing. Yet he found out that he was the lowest paid of them all. He made less money than his white colleagues, and he didn't know it. He just happened to find this out and took that issue up with the boss. Well, yeah, so although you think you're doing good, you think you're doing well, you're probably victims of discrimination that you don't even know about. until somebody opened your eyes to it. And be that as it may, as a group, the research is very, very clear that as a group, we deal with serious systemic institutional racism. Looking at yourself or looking at some other, your friends, and so on, that's anecdotal evidence, and we should never feel comfortable based on the anecdote, based on just the fact that we're doing well. And there has been progress since slavery and Jim Crow, no doubt about it. But in many ways, we're in the same situation we've been in. So what we're trying to do is show you the tension that the court is dealing with when Chief Justice talks about here the fact that the Supreme Court does not allow the 14th Amendment to look at groups. That's why it's ineffective in so many cases, because the court's opinions have so weakened the 14th Amendment that it doesn't really get to the core of the problem. It, again, looks at, the individual and not disparate impact, not disproportionate impact. So it really doesn't get to the root of the issues, which is systemic racism.
It doesn't. And you know, so these are the type of conversations that we as African Americans need to have in our own homes, that because I've also had people tell me, well, if affirmative action is going to make people look at me negatively or make people think that I didn't earn my spot at my job or in school, then we do need to get rid of it. And there's been polling out that most Americans disagree with affirmative action and thought that race should not be considered in college admissions. And a large number of African Americans that were polled as well thought the same thing. My response to that is, one, it's not about how others view us or view whether or not an African American goes to an elite college or college at all, because we know that that is an excuse. Because
Who
there's so
cares?
many legacy admissions, there's so many other types of affirmative action that are disregarded, that are not addressed. You know, the eighth, the seventh, eighth generation Harvard graduate who has 8 generations of Harvard graduates in their family. And Justice Ketanji, she addressed this in her dissent. That itself a form of Bush probably would not have gone to Yale if his father and his grandfather had not gone either. So we need to forget about what others are saying about us and things of that nature and focus on what our goals are, because we know that it's a dog whistle for racism at its core anyway. That would be my response to that.
Yeah. So you mentioned Justice Jackson. Let's bring her up. I had her comments for later, but we just need to bring her up. And you know what? I'm just so proud of Justice Jackson. So happy that she's on the court. Again, she represents the Thurgood Marshall wing of the court. And I know there are people out there black people who even go after her because she's married to a white man. Okay, I'm aware of that. All right. Look, given the way that she represents the Marshall wing of the court, you know what? I don't care who she's married to. And by the way, Justice Marshall was not married to a black woman either. He was married to, I believe, a Filipino. All right, but he's the lawyer who brought down the segregation in public schools, right, and became the first black justice on the U.S. Supreme Court. So, who cares who they're married to? That's ridiculous. So Justice Jackson says this, Chloe, in her dissenting opinion. She said gulf size race-based gaps exist with respect to to the health, wealth, and well-being of African American citizens. They were created in the distant past, but have indisputably been passed down to the present day through the generations. Every moment these gaps persist is a moment in which this great country falls short of actualizing one of its foundational principles, the self evident truth that all of us are created equal. Now, she has more to say, but let's understand why she said that. She said that because Justice John Roberts and Justice Clarence Thomas were trying to uh, say that we're all equal under the law. That's laughable. Despite the 14th Amendment, it's laughable that we're all equal under the law. We're not equal under the law. That's why she said there are wide gulfs, large gaps in wealth, in health, in income, in education, down the line. We are not equal under the law. Despite the 14th Amendment, despite it being added to the Constitution over 150 years ago, we are still, as a group, not equal under the law. That's a farce. Yet, Justice Thomas says this. Let's go back. He says, he wrote this in his concurrent opinion. He said in the 1860s, Congress proposed and the states ratified the 13th and 14th Amendments, and with the authority conferred by these amendments, Congress passed two landmark civil rights acts. Throughout the debates on each of these measures, their proponents repeatedly affirmed their view of equal citizenship and the racial equality that flows from it. In fact, they have held this principle so deeply that their crowning accomplishment, the 14th Amendment, ensures, he says, racial equality with no textual reference to race whatsoever. He says the 14th Amendment ensures racial equality with no textual reference to race whatsoever. The history of these measures' enactment renders their motivating principle as clear as their text, and I have underlined. All citizens of the United States, regardless of skin color, are equal before the law. That's preposterous. That's what Justice Jackson was getting at. That's what she was getting at. That there has never been, we have never been equal under the law. That's ridiculous. And that's why the 14th Amendment was added, to bring about equality. So if affirmative action or whatever program was designed to bring about the equality, they have so twisted the 14th Amendment that they now use it to invalidate the very programs that the 14th Amendment was added to create.
Yeah. That was going to be my point too, that there would be no need for an amendment if it were in fact true that all people are equal under the law. And that we keep saying the 14th Amendment, I want to read it for people because I'm sure most people may not know what the 14th Amendment even is. Um, but in part, it says that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. This is important. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That is what the 14th Amendment says. That is what we know as the Equal Protection Clause. So no state shall deprive any person of life, liberty, or property without due process of law, which is going through the court system, notice, allowing the person to respond, nor deny to any person within its jurisdiction the equal protection of the laws. So this is where we got Brown versus Board of Education. The Supreme Court used this language to say that separate and unequal schools separate but equal was unconstitutional because it violated equal protection of the laws. This is what the Supreme Court used with the Oberfall versus Hodges, the gay marriage with decision which legalized gay marriage. And this is what the Supreme Court has used in Bakke and other prior affirmative action cases to say that, look, there is a compelling governmental interest for there to be diverse student bodies at colleges. And in order to achieve that diversity, and in order to allow African Americans, which have largely been left out of higher education, which in the past where dolls were sicked on us when we would try to go to college and get an equal education. The Supreme Court has said under equal protection of the law, that diversity is good, and we should allow African Americans and others, and not just African Americans but others, women too, will largely benefited from affirmative action as well.
White
So to
women
come
especially.
back, yeah, yeah, to come back and then make the circle of reason to say, well, no, it's discriminatory. Affirmative action is now discriminatory because race is considered as one of the factors. It's just like you said at the beginning, Dad. This was an agenda of Justice Roberts and the other conservative justices from the beginning, and they were waiting for a case, like you said, the long game, to strike down affirmative action, basically.
All right, so let's ask the audience this question, because this is the rub. This is what this opinion bottoms out to. All right. So the Equal Protection Clause of the 14th Amendment basically says that states cannot discriminate against people based on race. Okay? Here's the question. Does that mean that states cannot use race under any circumstances? The state cannot pass any laws under any circumstances based on race. And when we say states, we're talking about state agencies too, like universities. Cannot use race under any circumstances, including even to help a particular race. Can a state or a state agency use race to help an underrepresented or an underprivileged racial group? That's the question the court addressed in this case. Can race be used to help an underrepresented or underprivileged racial group? The conservatives said no. We're of the opinion that they're wrong, because the Equal Protection Clause of the 14th Amendment was added to the Constitution to help African Americans who had been enslaved for 250 years. But that is the question. Chloe, did I explain the question okay?
Yeah, that's the core of the question. Can race be used to help or be used to in consideration of admitting an applicant to a higher education into a college? And just like you said, the Supreme Court said no, it can't. And they went into a lot too about whether or not affirmative action will negatively affect other races. In this case, Asian Americans.
Okay.
It,
That's
Justice
another
Roberts
that's
spent a
another
lot of
huge
time.
that's another
Yeah,
very, very important question.
yeah. He spent a lot of time in his opinion discussing that. And before we get into what the Supreme Court said, I was on Reddit earlier and just reading comments after this decision came down, and a lot of people who said that they were Asian or Asian American, they were applauding this decision. because they feel like they, work hard. They're children of immigrants. They have near perfect scores, and because they're Asian, they were not being admitted to these colleges. So a lot of people that are applauding this decision, who are not African American, specifically Asian American, from what I can tell from reading stuff online. Um, but in terms of whether or not
Well, hold,
affirmative
hold,
action,
hold. I want to opine on that. Okay,
mhm,
let me give my opinion on that critical issue. First of all, I would point out that the admission process for both Harvard and UNC looked at not just black race, look not just at the black race, but 5 categories of races were considered. Whites, I can't remember them all, whites, Asians, blacks, Latinos, and there's one more, probably um, Island
Native
Pacific.
American,
Who?
Native Americans.
Maybe natives. Yes, I think it was natives. So it wasn't like, okay, they looked at the application just to see if it was a black person. They looked at 5 different races to try to make sure that they had a diverse student body. So race was one of the factors, as you said, and it wasn't just because people think when they look at the application, they just look to see, is this person black? No, they considered whether the person was white, black, Asian, Native American, uh, or uh, or Latino. That's one. That's one point I would make to those folks, Asian folks who are celebrating this. Secondly, I would say it is because of the civil rights work of the African American community that Asians can come here and do well. Third, I would point out that a lot of the discrimination that African Americans face is targeted to us because we're black. So Asians, Latinos, many of them can come over here actually and classify themselves as white. I mean, on a lot of applications, Latinos are white, or Asians can be white. We cannot be white. We don't get to choose white for our applications and then get whatever privilege is associated with being white. And a lot of times our names give us away, right? If you got, if you check white on your application and your name is Jamal, or you check white on your application and your name is Shaniqua, right? They know who that is. But Asians, Latinos have been accepted into the white world. And Asians, again, come from their countries and they weren't here enslaved as Black Americans were for 250 years and then Jim Crowed. So their state is a lot different. And again, I think they should be appreciative. For example, the Immigration Act, that came about as a result of the Civil Rights Movement. And that's the reason why Asians are able to even immigrate to this country. So I don't think they should allow white conservatives to pit themselves against us like that. Um, that's an unfortunate outcome of what could also happen with this case. You know, Asians and Black Americans start, well, not start, but cause it to increase the animus between the two groups.
Yeah, yeah, because there's a lot of Asian Americans in Black communities, beauty supply stores, gas stations, nail shops, and we put a lot of money and wealth into their community with what return? really nothing, unfortunately. And the fact that Edward Blum, who was a conservative, white male conservative, who started this Students for Fair Admissions, found Asian American plaintiffs, started this whole process, and he was able to successfully get affirmative action abolished by pitting some of those tensions that have been there between Asian American, African Americans is sad as well. Um, and he came out with a statement too that I saw where he said that he basically they were going to continue to go after universities to make sure they adhere to what the Supreme Court ruled today with abolishing affirmative action. But one thing I do want to point out too, Dad, is Chief Justice Roberts, he kind of left a little wiggle room by saying that if an applicant mentions race in their application essay, that is fine as long as that's not the only consideration, but it kind of connects back to a character trait that they want to highlight. So even though race was affirmative action was struck down, there was that little nugget or tidbit that was left in there.
Yeah, I saw that language. Um, yeah, I saw that. I don't know if it has much of any effect because, again, I think the broad nature of the language that he wrote in the majority opinion makes it very, very, very clear and makes it clear to universities. You better not have anything about race on your application. If the student talks about how being an African American has caused this or that challenge, that's on them. But you better not you better not include it on your application, on your applications. All right, so Chloe, let me ask this question because these are the questions I think that folks want to know um, when they hear all the uproar about this affirmative action case. There are a couple of questions. All right, so and I think Justice Ketanji Brown Jackson brought it out best. She said, well, let me ask this. Do you think our Constitution is colorblind?
No.
What does that even mean?
And I say no because it was written by wealthy white men, and the original form of it left out African Americans and women. So if it can't be colorblind if the Constitution, intentionally leaves out minorities and all of these big groups because it was written for wealthy white men. I mean, by wealthy white men for wealthy white men. So I don't believe it's colorblind at all.
Well, I would go further and say that there are some you're right, it doesn't just say black people, but there are references in it that we know that's exactly who they're talking about, like the fugitive slave law, which is still in the Constitution. Um, the three-fifth persons clause, again, it doesn't, like you said, doesn't mention black people, but we know who that's talking about. So with those references in the Constitution that everyone knows is referring to black people, how can we say that it's colorblind? That makes no sense.
Yeah.
And so
It doesn't at
Justice,
all.
yes, so Justice Jackson, she says here, she said, our country has never been colorblind. Given the lengthy history of state-sponsored race-based preferences in America, to say that anyone is now victimized if a college considers whether that legacy of discrimination has unequally advantaged its applicants fail to acknowledge the well-documented intergenerational transmission of inequality that still plagues our citizenry. So here she addresses Asians, right? Here she says to say that anyone is now victimized Asians, if a college considers whether that legacy of discrimination has unequally advantaged its applicants, fails to acknowledge the well-documented intergenerational transmission of inequality that still plagues our citizenry. So in other words, she's saying to take in consideration, if the Constitution takes in consideration how blacks have been disadvantaged, that doesn't victimize Asians. That was the reason the 14th Amendment was added. So I think Asians have to realize that you're immigrating to a country with a history of chattel slavery and Jim Crow that resulted in a group of people being disadvantaged. And the laws were changed on behalf of those people. So so we have to we have to explain this to our Asian friends.
And I just want to point out that was a bar. For those of us who are lawyers, what she wrote about that quote that we put out about, can we go back to it? That's a bar. If she were a rapper, she would. To me, that's a mic drop moment. Given the lengthy history of state-sponsored race-based preferences in America, to say that anyone is now victimized if a college considers whether that legacy of discrimination has unequally advantaged its applicant fails to acknowledge the well-documented intergenerational, generation by generation by generation is what she's saying, transmission of inequality that still today plagues our citizenry. Woo! Let's go, Justice Jackson. Yes, ma'am. She dropped a bar right then. I mean, that just got me excited because she directly addressed the Asian American plaintiffs and the other plaintiffs in this case and said that, look, there's a history of discrimination against black people in this country. And if you fail to acknowledge that, then you are failing to acknowledge the generational trauma and transmission of the inequality that has come since we've been in this country over 350 years ago. That's basically what you're trying to do. That's what she's saying, you all, in that quote.
And I would also point out that not all Asians agreed. There were 38 Asian organizations that filed amicus briefs in opposition to students for whatever they call themselves. 38 Asian organizations filed amicus briefs who basically stood with African Americans here in support of affirmative action.
And I saw some Asian American protest against the Supreme Court abolishing affirmative action. So there were definitely some who agree with us as well, a large majority.
So now Justice Jackson, she just did so well here. She said, so Chloe, let me ask you this. I'm trying to keep it practical. If you have two folks in North Carolina, in fact, let's read what she said. She said, imagine two college applicants from North Carolina, John and James. We're from North Carolina. Okay, we know what she describes here is very real. She said, John and James both traced their families' North Carolina roots to the year of UNC's founding in 1789. For example, our family, I traced our roots back to about 1840. Our enslaved ancestor's name was Thomas Williams and his wife, Emily Williams. All right, so we can literally do that. Both love their state and want great things for its people. Both want to honor their family's legacy by attending the state's flagship educational institution. John, however, would be the seventh generation to graduate from UNC. He is white. James would be the first. He is black. Does the race of these applicants properly play a role in UNC's holistic merit-based admissions policy? The inability to build wealth through that most American of means forced black people into sharecropping roles where they somehow always tended to find themselves in debt to the landowner when the growing season closed, with no hope of recourse against the ever-present cooking of the books. Sharecropping is but one example of race-linked obstacles that the law and private parties laid down to hinder the progress and prosperity of black people. Vagrancy laws criminalized free black men who failed to work for white landlords. Many states barred freedmen from hunting or fishing to ensure that they could not live without entering de facto re-enslavement as sharecroppers. A cornucopia of laws banning hitchhiking, prohibiting encouraging a laborer to leave his employer, and penalizing those who prompted black Southerners to migrate northward ensured that black people could not freely seek better lives elsewhere. And when statutes did not ensure compliance, state sanction and private violence did. History, in some form, it can be heard forever. The race-based gaps that first developed centuries ago are echoes from the past that still exist today. By all accounts, they are still stark. So when we go back to John and James, John has had all this privilege over these years, whereas James has had all these obstacles. Is it a bad thing under the 14th Amendment to look at John's obstacles, all that he has had to suffer as his application is submitted and is being and competes with the white guy's application who's 6 generations deep in UNC? That's legacy, by the way. That's legacy admission. They didn't say anything about that. That primarily benefits whites. So nothing about legacy. All right. So if we're not going to look at stuff, let's not look at stuff. All right. But Chloe, shouldn't the 14th Amendment be used to give some help to the black guy who came from that history as he competes with the white guy who is a 7th generation UNC Tar Heel?
Absolutely.
Absolutely.
Absolutely. Yeah. I mean, to me, there's no question about it. Just what Justice Jackson has said in describing, the difference, the stark gap between John and James and John's family, who's been in North Carolina from 1789, and James's family, who were enslaved and then freed and subject to sharecropping and Jim Crow laws, etc. I mean, to me, the question is absolutely. Um, I was listening to some people discuss this, some pundits. One was a black liberal, one was a black conservative, and maybe we can get to this later, and maybe in a part two. But there were a lot of things that were brought up by the black conservative that I want us to address.
Okay.
They're not as legal as much, so I think they would be best in part two.
Okay.
Um, but things, for example, of um, the black conservative said, "Well, I want my children to go to a school that has diversity in thought, not just diversity in color." That was one of his um, his negatives about affirmative action. And then another criticism he had about affirmative action is saying that it allowed basically unqualified or underqualified African American students to be admitted and then suffer academically. And some of them don't end up graduating or have to suffer the stigma of people just thinking, like mentioned earlier, that they got there on campus because of affirmative action. So I know that these are thoughts that a lot of just black people have in general, or black conservatives and other conservatives. So I think we should address that in a part 2 video.
Okay, sure. So we can do a part two. We're regularly scheduled to do our show on Saturday anyway, so we can address it then.
Yeah, because
Okay.
I feel like those are some of the more practical questions too, just outside of the legal implications, but the what people are thinking. Even Caleb called me and asked me a similar question.
Which was
Um, how did he put it? Basically, does it how he brought up how Clarence Thomas always talked about how he was made fun of and how he was ridiculed. Sorry guys, my brain at this
ridicule.
time ridiculed. Excuse me, ridiculed. At the Ivy
I
Leagues
do
that
that
he
all the
attended.
time. I
Yeah.
I have to practice it in my mind before I say it.
We're filming later than we usually do, and I have to. But anyway, ridiculed how he was ridiculed at the Ivy Leagues, and he subscribed it to because of affirmative action, and the other students thinking that he was not there on his own merit. So I've heard that refrain a lot from people who are either apathetic about affirmative action being overturned or actively against it as well.
But, so my quick response to that is, why care about what white conservatives or white racists, white supremacists say? Why even care? I mean, who cares? There's nothing that if a black guy showed up, UNC, Harvard, or whatever, with a 5.0 grape on average, okay, and a 1600 SAT score, or whatever the high score is, right? They still would find some reason to say he still got some sort of advantage or some sort of benefit, or he's just not as intelligent as somebody else and he still doesn't belong and shouldn't be there. We can't please those folks. We can't seek to please those folks. I mean, they have their bent, they have their prejudice, their racist, their biases. They have, their ideology. They see themselves in opposition to us. So it doesn't matter. We'll never earn their respect. We got to do what we got to do. We just got to do what we got to do. I remember when I graduated college with my degree in chemistry, I was offered a job um, right out of college. In fact, before I graduated, as a chemist. You were a baby at that time. And the guy who offered me the job, his name was Monroe. I remember him to this day, a white guy. He said to me, we knew, and this is an affirmative action hire. He said, we knew we wanted to hire a black person. This is what he told me. But we wanted a good one. This is what he literally told me to my face. So he basically said, you are an affirmative hire, but we wanted a smart one. I went to one of my professors. I said to him, Dr. Such and such and such. I said, this is what this guy told me. Would you take this job? I mean, this is blatantly racist, discriminatory. And he said, no, I would not. I would not. Well, I graduated college in 1989. When were you born, Chloe?
90.
You were born the same year this guy offered me this job. So I went home, thought about what Dr. Williamson said, then looked at you. You barely are a month or two old. I said, look, I got to take this job. This is the most money I ever made in my life. I got to take this job. So I took the job. I was the first black chemist they hired. And yes, there were times when if something was not um, right, Monroe would think it was something that I didn't do right. Okay? It was something he thought I didn't do right, and I had to prove that I did it right. So yeah, I dealt with all that, right? But I didn't care. I knew I had earned my way there. And I was at an HBCU, by the way. I went to A&T for undergrad. So I didn't have to justify my presence there as an affirmative as someone who was in college on affirmative action. But it was an affirmative action hire because they specifically said they wanted to hire a black person, but they wanted a good one, a good chemist, a good black person. Looking back, but as I look in your beautiful face, you were the reason. I said, I can't turn this job down willy-nilly. I mean, I got a mouth to feed. I'm a father. I got a newborn baby. I'm married. So I'm just have to deal with it. So my point is, I wouldn't care what they say.
Yeah. You brought up your HBCU dad that you went to. I've also heard some people say, well, maybe this decision will encourage more black people to go to HBCUs instead of, you know, the Harvards or the UTs, etc. Um, what do you think about that?
Well, I think that if a person chooses to go to an HBCU, that person has made a great choice, which is responsible for most of the black professionals in this country. However, I think that should be because the black person makes that choice willingly, not
Yeah,
because, he can't get into the other school. It should be a willing choice.
yeah, I agree. I agree. I think um, as a graduate of an HBCU law school, great alternative. But like you said, it should be a decision that is made by that black applicant, not because just they feel like they have to, which is what we had to do, and which is why black universities were created in the first place because we didn't have access to higher education. That's another point. That's why we have historically black colleges and universities. And affirmative action was put in place, first with JFK administration, the LBJ administration, to solve those gaps. But affirmative action is not an end all be all until, and we've talked about this, until this country has a true reckoning and reparations and repair everything that this country has done to African Americans, even with affirmative action and, well, now no affirmative action, that was not going to cure the stench of injustice in this country. We need to go back from the beginning and really have a reckoning with ourselves. And um, hopefully, this decision would get more people that interested in the law, in politics, in running for local elections, and voting as well, because they see that elections really do have consequences.
Well, let me ask you a question. You graduated Arlington High School here in DFW. You graduated in like the top, what, 3, 4, 5% of your class?
Hmm.
And this was at a time where if a Texas high schooler graduated in the top, what, 10%, they were able to go to any um, public university in the state, right?
Yeah.
So you literally earned your way and you went to UT Austin,
Hmm.
right? Like Chapel Hill's the flagship school in Texas. Did anyone ever question you about how you made it to UT Austin? Did anyone say to you, or did you feel like, you were being looked at as an affirmative action student?
No, because I knew I was in the top 10%. Y'all can't take this away from me. I got in just like my classmates who were in the top 5%, automatically got into UT. So at UT I didn't. But I have felt more as an attorney, being a black female attorney, where we make up less than what 2% of practicing attorneys in this country. I've felt it more in this regard than I did in undergrad, to
Felt
be
what?
honest. Um, I felt more questioning of, are you qualified to be an attorney, or different treatment from other types of lawyers, um, getting different looks, people not thinking that I'm the lawyer, people thinking I'm the client or the social worker. I've experienced that a lot. So I felt it more in a professional sense than I did in undergrad, because I knew, and you couldn't tell me nothing. I got in UT just like you because I was in the top 10% of my high school, which was a very competitive high school here in Texas.
So doesn't that
So
prove the point that no matter what we do, we're still going to be questioned? They're
yeah,
still going to consider us to be less qualified. I mean, you went to an HBCU
yeah,
law school, as did I. Um, and so you weren't an affirmative action student at a white law school. You went to an HBCU, and they yet found some way to question your qualifications. They're going to do that regardless. It doesn't matter, which is why I don't think we should give any credence to what they have to say about us going to, well, we won't be able to now. We shouldn't have given any credence to what they felt about us getting to the university on an affirmative action program. By the way, Clarence Thomas, that's how he became a Yale law graduate. It was an affirmative action. Yale confirmed that it was an affirmative action, um, decision to allow him in. Um, so I think bottom line is back to John and James. If you got a white applicant who has all the advantages that the black applicant does not have, or even the Asian applicant doesn't have, should the black guy get some special consideration given the fact that he has likely, again, his great great grandparents were enslaved, his great grandparents were Jim Crowed, his parents dealt with sharecropping. He deals with systemic racism, which affected the schools that he attended, which has impacted his life for generations. Shouldn't that guy get some special consideration when other races of people have not dealt with those systemic injustices?
I think that he should. I think, just like Justice Jackson said, there's been a inter intergenerational transmission of that racial injustice, and um, yeah, I think that I think that it should, and I think that that's what the 14th Amendment was designed to do. So
So, so Justice Jackson says, most likely 7 generations ago, when John's family was building its knowledge base and wealth potential on the university's campus, James's family was enslaved and laboring in North Carolina fields. 6 generations ago, the North Carolina Redeemers aimed to nullify the results of the Civil War through terror and violence, marauding. Now, that's a word I may have just botched. Marauding in hopes of excluding all who look like James from equal citizenship. 5 generations ago, the North Carolina Red Shirts finished the job. 4 and 3 generations ago, Jim Crow was so entrenched in the state of North Carolina that UNC enforced enforced its own Jim Crow regulations. Generations ago, North Carolina governor still railed against integration for integration's sake, and UNC black enrollment was minuscule. So, at bare minimum, one generation ago, James's family was 6 generations behind because of their race, making John's 6 generations ahead. So, to address that, isn't affirmative action, I mean, worthwhile, wasn't it? I mean, why was it so bad when it was addressing these systemic issues that Black Americans have faced?
Well, I feel like, conservatives and just some black people in general have been very successful. And basically, what we started with the beginning from Justice Roberts, where he said that um, it, the individual is important, not the group, not systemically. Because, like I said before, you hear critics say, well, a black wealthy applicant is not the same as a poor black applicant. And most applicants applying to Harvard or these Ivy League schools are wealthy. I don't know how true that is. They didn't provide any statistics, but I think it's just um, that misinformation and those lives that have tainted a lot of people. And apparently, the Supreme Court interpreted that way. At least the conservative justices did, where it's not James typically who's being benefited by affirmative action. It's someone who is coming from a wealthy family, is what I've heard. Yeah.
Yeah, Clarence Thomas came from poverty out of Savannah, Georgia, went to Holy Cross University. I think that's where he graduated undergrad and then was accepted into Yale on the affirmative action program. That was not a rich person benefiting from affirmative action. It was a poor black dude from Georgia, right? And by the way, who was appointed jobs after he graduated law school. He was given jobs on affirmative action programs. He made it to the court because he was a black conservative, not because of his merit, not because he was the smartest or most qualified in the bunch, but because he was a black conservative, and they knew that he would take the position and had the position that he has espoused over the last 40 years. So he didn't earn his way either. He was placed in those positions to do the damage that he has done. And I say all that respectfully. I say all that respectfully because we have this duty in our canons to not be disrespectful to the bench. So I say all that respectfully. Okay. So Chloe, part 2. So there ought to be a part 2, right?
Yes. There's so much more we can discuss. Just about what are the implications on other areas, like we were saying before, Brown versus Board of Education, these other hot button target areas that may be targeted because of this decision. Practically, how does this look? We're going to be having a new crop of people applying to colleges. How does that look? Um, what does this mean for the Supreme Court in the future? How could this bode well for other cases that might be come before the Supreme Court? So yeah, we have a lot more to discuss. That this was just the introduction.
All right. So we're going to jump back on it Saturday, doing our regularly scheduled live event. Chloe, it was good. It's just so much to talk about, and then trying to break it all down so our audience can understand it. All that is tough, but we did it as best we could, but we just scratched the surface. We got a lot more. But that's going to end our show for today. You all, thank you for tuning in. Get back with us. As a matter of fact, why don't you leave your questions in the comments section,
Yes.
and we'll get to some of those questions this coming Saturday at 2 p.m. 2 to 3, but Typically, we try to do 2. It may be between 2 and 3. But again, thank you for showing up today. And this was a horrible decision that's going to have a lot of ramifications for our nation going forward. But we are resilient people. We will survive. In fact, we will thrive. We will rise like a phoenix. All right, so that is it. You all have a good one. See you back here Saturday.
Ever since I was a child, I've always hated bullies. I was that child. If I saw another kid getting picked on in class or at the lockers, I would stand up for that kid. I couldn't stand seeing bullying. But there was one incident with a teacher that almost silenced me. It is my first clear memory of racism and discrimination. It's still so vivid and clear in my head. I remember there was some one by one up to her so that she could paint our face. When it was my turn to get my face painted, my teacher told me, "I can't paint your face because your skin is too dark." I was mortified, embarrassed, and deeply ashamed. In that moment, even though I wanted to say something, I couldn't get the words out. So I walked back to my desk, I sat down, and I stared blankly at my desk until the bell rang. When I got home from school that day, my parents knew something was wrong. But I remember being so reluctant to tell them. I really don't know why. When I finally did, obviously they were furious. And let's just say the next day at school was one to remember. But this incident taught me a valuable lesson. It taught me to always stand up against racism, discrimination, and injustice. It fortified my resolve to fight for the vulnerable and voiceless. Just like my clients' voices are taken when they are wrongfully accused of a crime, subjected to banking while black, fighting for custody of their children, or fighting for just compensation from stingy insurance companies. My name is Attorney Chloe Corbett, also known as the Duchess of Justice. I am one half of Corbett & Corbett Law Firm and the Defiant Lawyers. We're here to fight for justice for the accused, the oppressed, the vulnerable, and the voiceless. You can find us in Dallas, Texas. Go to our website, www.corbettfirm.com. Improving lives and impacting laws.